This is Radhika Pasrija on the third episode of Politics, where we will understand the three new criminal laws and the advantages and challenges they put forth. How would you address a person who is a cheat or fraud and acquires something using deceitful means? Colloquially, the person is referred to as 420. This is so because Section 420 of the Indian Penal Code, that is IPC, included provisions that dealt with such crimes, but not anymore. The Government of India rolled in three new criminal laws on July 1 this year to reform, as they say, the country's criminal justice system. So now, if one wishes to use such an expression for a person who is a cheat, the cheat will have to be addressed as 318. The new laws will replace the IPC, the CrPC, that is Code of Criminal Procedure, and the Indian Evidence Act with Bharatiya Nyaya Sanhita, BNS, Bharatiya Nagarik Suraksha Sanhita, BNSS, and Bharatiya Sakshya Adhiniyam, BSA, respectively. Now, talking about the advantages of these laws, we will first talk about the aspect of expansion. Why? Because it brings offences like terrorism, mob lynching, and organized crime under penal laws, expanding it beyond the existing UAPA, that is, Unlawful Activities Prevention Act. Next is zero FIR, allowing people to register a police complaint at any police station regardless of where the crime occurred. Then comes the most important aspect of the new laws, information and communication technology or ICT applications. They will propose video recordings of search and seizure operations and an increased use of electronic evidence and forensics during an investigation. Interestingly, community service has also been introduced as a new form of punishment, which is a progressive approach. Also, speedy justice has been tried to ensure by advocating video trials and holding trials even in the absence of the accused. In line with the Supreme Court rulings, attempted suicide and adultery have been excluded from the new criminal laws. As far as the under trials are concerned, the police superintendent will have to ensure that an application is made to the court to release under trials who have completed half or one-third of their maximum possible sentence. But what are the challenges associated with the new laws? Clause 172 in preventive action of the police of the BNSS has given excessive power to the police. It states that people must conform to directions of the police issued in the course of preventing the commission of a cognizable offence. There are grey areas in the way sedition law has been defined. Though the offence has been judiciously tempered by introducing a test for criminal intent, but a new clause punishing quote-unquote acts endangering sovereignty, unity and integrity of India has been created, again giving the police unchecked powers of arrest. Secondly, there is a degree of vagueness in these laws. How the offences are drafted continues to perpetuate the problem of vague criminal law provisions that worsen the risk of arbitrary arrests. The laws should have reviewed the offences relating to religion and blasphemy. Then there are a few borrowed legislations on organized crime and offences under UAPA without a proper clarification on the reasons for such borrowing. The laws criminalize speech as offences, including sedition and obscenity, require reconsideration. Another major drawback is that marital rape has not been criminalized despite India having tough laws to prevent sexual violence against women. The term modesty employed in the new code for the offence of outraging the modesty of a woman is a sign of Victorian morality. Also, the new laws have done little to resolve how bail is adjudicated and accessed. Without appropriate changes in the evidence legislation or recovery evidence based on statements to the police, torture during the investigation will continue. The new criminal laws have removed the reference to thugs and punishment for them, but have retained outdated provisions and more than 80% of the 160-year-old IPC. They have introduced an institutional challenge as the laws propose that every crime scene must undergo forensic investigation. But the collection and analysis of forensic evidence and how they are used in courts, that remains unaddressed. The police custody for an arrested person has been expanded from 15 days to over 60 to 90 days depending on the offense. But of course, the effectiveness of these reforms is yet to be tested based on their impact on the most vulnerable sections of society. So, the question is whether these new laws are post-colonial or pre-colonial. Do tell us in the comments section below and stay tuned for more such content.